Hello students, welcome to the class. Welcome to the class on Indian polity and constitution. I once again welcome to you all to the Indian polity constitution series for group 1 prelims TSPSC. And the topic today we are going to discuss is utmost important topic for your exam or any competitive exam in India, conducted by TSPSC or UPSC. And this topic is, friends, fundamental rights. Fundamental rights. Fundamental rights is discussed in part 3 of the Constitution from Article 12 to 35. Article 12 to 35. Friends, generally, rights in India or anywhere in the world are divided into 3 types. Rights are divided into 3 types. The first one is called natural rights. The second one is called human rights. And the third one is called the constitutional rights. The first one is called natural rights, which are given directly by the nature, like for example, sunlight, right? Sleep. These are the natural rights. You have sunlight directly given by the nature. Air directly given by the nature. These are natural rights. Those natural rights which are only for humans is called human rights. And these are codified by United Nations organization. These are codified by United Nations organization. Now, what is constitutional rights? Constitutional rights are again divided into 2 types. That is fundamental rights and legal rights. Those rights which are directly enforceable, directly from the Constitution, is called fundamental rights. Fundamental rights do not need a specific legislation for its implementation. Fundamental rights are directly enforceable. For example, India. In India, the fundamental rights are discussed in part 3, which are directly enforceable and protected also. Now, what is the meaning of legal rights? Legal rights need a law to be enforced. A law is needed to enforce the legal rights. For example, Article 300A, right to property, they need a law to be enforced. Article 326, right to vote, they need a law to be enforced. So, these fundamental rights are very, very important because they are guaranteed directly by the Constitution of India and they are also enforced directly. They are also enforced directly. They don't need a legislation to be enforced. Such kind of rights for the first time in the world is given in 1215 AD. Such kind of rights for the first time in the world is given by 1215 AD by King John Edward. These rights given by the King John Edward of London is called Magna Carta. Magna Carta. But as these rights are not constitutionally recognized, they are given directly by the king. So the reason they are not called guaranteed rights. In India, our fundamental rights are directly from the Constitution of India. So they are called guaranteed rights. They are called guaranteed rights. But these are not called guaranteed rights. Fundamental rights are very, very important, friends. Discussed from Article 12 to 35, which are directly given to the people by the Constitution. No law is needed, not at all needed. Very, very important. And India got inspiration from US Constitution. India got inspiration from US Constitution, where from USA, we have inspired and taken fundamental rights concept into India called Bill of Rights. In USA, these rights are called Bill of Rights. In USA, these rights are called Bill of Rights. Friends, as you all know, fundamental rights is a very important topic. I will be doing 2 classes on fundamental rights. This class will be focused on the basics, the nature, the objective and few basics articles. And the next class I will be again doing with fundamental rights only, which has core concept, amendments, Supreme Court judgments, etc. Now let's start with the first question with regard to fundamental rights. Yes. Question number 1. If you look at this question, try to read the question, try to underline the word which is important and solve the question. Consider the following and choose the correct statement. Okay, he's directly asking what is correct statement. Correct statement. Fundamental rights are provided in the Indian Constitution. Fundamental rights provided in the Indian Constitution is not absolute. They are not absolutely given. This is a general statement. This is a general statement. It says fundamental rights are not absolute. Because, this is correct, because they can be restricted. Fundamental rights are not given completely. Fundamental rights, Article 14 says right to equality, but on the other hand there is reservations. Fundamental rights under Article 19 says right to speech and expression. You can speak anything but not against the country. So all fundamental rights are given to the people with maximum restrictions. But why I put general? There are few fundamental rights which are actually absolute. Because this is a generalized statement, this is correct statement. This is correct. But there are few fundamental rights like Article 17 which talks about abolition of untouchability. This is an absolute fundamental right. No restrictions are required. Abolition of untouchability. Prohibition of child labor. Prohibition of devadasi, prostitution system. All these are absolutely, we have to enforce it. This doesn't require any restrictions. So, but generally the statement is correct. Fundamental rights are not absolute. Now, once a fundamental right is given to the people directly by the Constitution, fundamental rights cannot be waived off by a citizen. They cannot be waived off. This is also correct. Can you say no? If Constitution guarantees you the freedom under Article 19 or 14 or 21 or any 15, can you say I don't want the fundamental right? By the virtue that you are an Indian, you get the fundamental rights. By the virtue that you are an Indian, you get the fundamental rights. You cannot waive off. You cannot cancel your fundamental rights. Both the statements are correct. Yes. Consider the following and choose the correct statement. Again, correct statement. So easy. Fundamental rights are enforceable directly. Absolutely correct. This I explained in first only. First only I have explained about this. Fundamental rights are enforceable directly. See, when one statement is easy, the second statement you need to think. Imagine, try to learn how I am solving the question, how you have to solve the questions, what points to be noted here, which words to be underlined. Look at the second statement. Writs can be issued by Supreme Court. Okay, can. See, can. The word can is important here. By Supreme Court, High Court and subordinate courts for protecting fundamental rights. See, we all know as per Article 32 of the Constitution and as per Article 226 of the Constitution, Supreme Court and High Court can come up with writs in protection of fundamental rights. We have studied about this. When a person study about this only, he will think this is wrong. But when an aspirant study the Constitution thoroughly, he will see can, and he will say this is correct. Even the subordinate court can issue writs. This is written in Article 32, Clause 3. According to Article 32, Clause 3, Parliament may by law can enforce fundamental rights by issuing writs. See, not directly. For Supreme Court and High Court, directly you can enforce it. That is a point. But coming to subordinate courts, not directly, but Parliament has to give that authority to the subordinate courts. So even this is correct. C is the answer. Many people think answer is 1 only. So be careful with these questions. Okay, next question. Which articles of the Indian Constitution or which article of the Indian Constitution discuss about the concept of procedure established by law? See, this concept of procedure established by law, as a concept we bought into Indian Constitution from Japan. We bought this from Japan. According to this procedure established by law, the state cannot take away the life and liberty of any person except following the procedure established by law. The state cannot take away life and liberty of a person except by following a procedure which is established by law. So, the state has to follow a procedure given by the law to take the life and liberty of a person. As these words, if you listen to this, you will get to know the answer. This is discussed directly in Article 21. Now, look at the question. Article 25, right to religion. Article 14, right to equality. Article 39 talks about many things. Directive principles of state policy. Answer is none of the above. Because the answer, direct answer will be Article 21. Article 21 says, the state shall not take away the life and liberty of any person except following a procedure which is established by law. Contradictory to this is due process of the law. So, in the famous Menaka Gandhi case, Supreme Court has introduced and said both the concept has to be followed in validating a law made by the legislature, and introduced the concept called theory of golden triangle. Golden triangle theory, according to which every law shall follow Article 14, Article 19 and Article 21. If any law is not following any of these three laws, then that law is considered completely unconstitutional. So, this is golden triangle theory. I want everyone to understand. Which of the following is not the nature of the fundamental rights? See, not. Okay, let us see what are the natures of fundamental rights. Now, fundamental rights are provided to both Indians and foreigners. Correct? This is correct. Absolutely correct. Okay, we'll get back to that. Fundamental rights are not provided to illegal citizens. This is also correct. It is not provided to illegal citizens. A person is declared as illegal citizen once a case is registered on any person under Passport Act and Foreign Act. If any case is registered under these two acts, that person is called an illegal citizen. Okay. Some fundamental rights are exclusively for Indians. This is also correct. Right? Article 15, Article 16, Article 18, Clause 2, Article 19, Article 29, Article 30. These fundamental rights are only for Indians. So some are only for Indians. This is also correct. Fundamental rights are inspired from US Constitution. This is leaked. This is also correct. Sir, what is this? If all the statements here seem to be correct, then the question is, which of the following is not the nature of the fundamental rights? Now, there is no answer. You think there is no answer? There is an answer. Option A and option C is contradicting itself. See, even though this is a generalized statement, because all other options are correct, you have to think about this statement in a specific form. Now, thinking about this statement in a specific form, fundamental rights are provided to both Indians and foreigners except a few. If except a few is there, this would have been completely correct. Because except a few is not there, this is wrong. What are they? What are that except a few? These articles. These articles are only for Indians, na? So, other articles are for both. Imagine like that. But some articles are only for Indians, so this is wrong. But generally speaking, this is correct. This is how you need to think and answer. Imagine how you will be in the exam hall. You need to take the pressure today only, tomorrow only, not at the time of the exam. Okay. Now, next question. Which of the following is or are the correct statement with respect to definition of the term state? Right? State as a term. State as a term is defined in Article 12 of the Indian Constitution, correct? Along with Article 12, Article 36 also defines the term state. Any organization funded by government is part of the state. Absolutely correct. According to 𝗳𝗏 𝗬𝗁 versus Airport Authority of India case. According to 𝗳𝗏 versus Airport Authority of India case, any organization which is funded by the government is part of the state, completely funded or more than 50%. 𝗧𝗦𝗔𝗧 doctrine is linked to Article 12. This is also correct. What is 𝗧𝗦𝗔𝗧? Of same nature. In reviewing Article 12 of the Constitution, Supreme Court came with 𝗧𝗦𝗔𝗧 doctrine in a famous case called Shantabai versus University of Madras. In this famous case, Supreme Court came with a famous doctrine called Doctrine of 𝗧𝗦𝗔𝗧. According to Doctrine of 𝗧𝗦𝗔𝗧, this of same nature of work is something you need to remember for your exam. So, answer is 1 to 3. E is the answer. Okay, 3H. Fundamental rights establishes. Fundamental rights established. This is a question. What is the objective of fundamental rights? Rule of law, doctrine of constitutionalism, political rights to the people. See, you have read fundamental rights provide political rights to the people. So, 3 is correct. So, this is wrong. This is wrong. Answer can be 2, 3 or 1, 2, 3, right? Now, what is the meaning of constitutionalism? Constitutionalism. Go with 2 important things. 1. Law is supreme. Law is supreme. 2. State has to follow that law. And if state will follow that law, the government functioning is limited. So, there is a limited government functioning. Limited government functioning. Now, look at this carefully. Law is supreme. What is law is supreme? Rule of law. Rule of law is nothing but law is supreme. In any country, there is rule of law. In that country, law is supreme. What is supreme? Law is supreme. Now, what is the second one? Now, imagine there is fundamental rights. Law. Constitution is the primary law. There are fundamental rights. Suppose I am the Prime Minister of India. Imagine I am the Prime Minister of India for 30 seconds. Imagine. Now, after becoming the Prime Minister of India, Adani is my close friend. Ambani is also close friend. I want to give subsidies for them. What? You want to give subsidy for the richest man in Asia? Richest man in India? How is it possible? It is against your fundamental right. It is against the fundamental right. Imagine if I bring that law. This law is challenged in the court. The court will declare it as invalid because it is against the fundamental right. Now, as a government, if I am trying to do some work, fundamental rights are coming and making my work limited. Limited government. Fundamental rights ensures limited government. Answer is C. Very important concept. Next question, ma. Consider the following and choose the correct statement. Choose the correct statement. Simple. Choose the correct statement. Okay. Article 19 is automatically suspended in case of emergency declared under national emergency. Emergency declared under national emergency. Correct. I'll explain this. Article 14 can also be suspended by the parliament law in case of national emergency. Okay, let us discuss this now. See, fundamental rights can be suspended. Can be suspended. 1, 2, 3. According to 3 circumstances. Article 34, Article 358, Article 359. According to Article 34, whenever military rule or martial law is imposed in India, whenever military rule is imposed in India, fundamental rights can be suspended. It was never imposed till now, so there is no restriction on your fundamental rights. Now, according to Article 358, listen to this carefully. It says, whenever national emergency is imposed in India, fundamental right guaranteed under Article 19 is automatically suspended. According to Article 358, whenever there is a national emergency declared in India, fundamental rights guaranteed under Article 19 is automatically suspended. Automatically suspended. This is correct statement. This is correct. Now look at this. What is 359? Except Article 20 and 21, except Article 20 and 21, other fundamental rights can be suspended by a presidential order. By a presidential order. Meaning, except 20 and 21. Here it is 14. So 14 can be suspended. But according to Article 359, Article 14 can be suspended by a presidential order, not by a parliament law. So this is wrong. Answer is A. Imagine, this is how you need to read. Which of the following is or are part of Article 21? Right? See, two unique things about Article 21. Article 21 is the shortest article of the Indian Constitution. Shortest article. And most reviewed article. Most reviewed article of the Indian Constitution. For example, recently Supreme Court said, right to livelihood of sex workers, prostitutes is part of Article 21. Prostitutes or their profession is part of right to livelihood as discussed in Article 21. Prostitution was not made legal in India. Prostitution has been recognized as a livelihood by Supreme Court recently in a judgment under Article 21. This is how Article 21 is reviewed. Article 21 talks about right to life and personal liberty. And personal liberty. Right to life and personal liberty. Now look at this. Right to sleep. Right to healthy environment. Right to privacy. Right to travel abroad. Right to marry of your own choice. All these are part of Article 21 declared by Supreme Court in many famous cases. So answer is all. C is the answer. One important point you need to remember is right to privacy. Right to privacy is declared as part of Article 21 by Supreme Court in Justice Puttaswamy. versus Union of India case. Versus Union of India case. This is also called Aadhaar case. So, right to privacy has been declared as right under Article 21. Recently, there is a famous case called Anuradha Basin. Just give me a minute. There is a famous case called Anuradha Basin versus State of Jammu and Kashmir. Anuradha Basin versus State of Jammu and Kashmir, where Supreme Court declared right to access of internet. Access to internet is part of Article 21. Okay. So, this is a famous question. Every year, one question is asked from this topic. Every year, Article 21 in all competitive exams, including your UPSC. So, Article 21 or Article 21 based questions are expected. So, be careful. Maneka Gandhi case is associated with which of the following article? Maneka Gandhi versus Union of India case is a very famous case which made Supreme Court of India review one famous article. I told you just before, that article is the most reviewed article, and the article is Article 21. Okay, let us see what is Maneka Gandhi case. Before that, Article 19, it talks about, it guarantees certain freedoms to citizens. Right? In the original constitution, there were 7 freedoms guaranteed. Presently, there are 6 freedoms guaranteed. Right to freedom of property has been deleted under Article 19 by 44th Constitutional Amendment Act of 1978, and this is added to Article 300 capital A. So, remember this. Article 20 talks about, right, protection provided to convicted persons. There are 3 types of protections. No ex post facto, no 𝗹𝗶𝗁𝗍, no self-incrimination. No ex post facto, no 𝗹𝗶𝗁𝗍, and no self-incrimination. Now, what is Article 22? Again important. Protection for detained persons. What is the meaning of detained persons? Arrested persons. See, there are 2 types of detentions. Punitive detention and preventive detention. When any person is arrested after committing the crime, that is called punitive arrest, punitive detention. You have committed the crime, you got arrested. When any person is arrested without committing a crime, right, there is a possibility that he is going to commit a crime. So, that's why police will arrest you. Now, police has detained you to prevent something crime you are going to conduct in the future. So, Article 21, it talks about Maneka Gandhi case, Article 21. Because of Maneka Gandhi case only, golden triangle theory got emerged in India. I told you what is golden triangle theory. According to golden triangle theory, all the laws made by the legislature shall be aligned to 3 major articles. 1. Article 14, 2. Article 19, and 3. Article 21. If any law made in the legislature is against any of these 3 articles, that law can be declared as unconstitutional or invalid by Supreme Court. So, these are few questions which I wanted to discuss about fundamental rights today in this class. I am not going to leave fundamental rights and end the topic here. I will be taking one more class on fundamental rights only. My next class will be again on fundamental rights only. We will see more concept involved with fundamental rights. Till then, keep learning, happy learning. Thank you very much. Jai Hind.